Hello, and welcome to Monday Bagel, the podcast where we explore the intersection of law, technology, and society. My name is Michał Jackowski, and today I'm truly honored to be joined by Professor Frank Emmert, the John S. Grimes Professor of Law and Director of the Center for International and Comparative Law at Indiana University McKinney School of Law. Frank is a fellow of the Chartered Institute of Arbitrators with over 30 years of experience in international disputes. He's been teaching AI regulation since 2017, long before it became fashionable. And what makes today's conversation particularly timely is Frank's work supporting the Silicon Valley Arbitration and Mediation Center Task Force, where he's supporting development of guidelines for AI in arbitration. Today we'll discuss this fascinating topic, what we need for AI in both courts and arbitration. Frank, thank you for being here with us.
It's a pleasure, Michał. Thank you for having me.
So last surveys, including Sedona conference survey, show that over 60% of federal judges have used AI in their work, but only 5% use it daily. What's your idea? What's holding judges back from more regular use of artificial intelligence?
Yeah, I think first we should understand these numbers are self-reporting. Right, so we don't have someone standing with like a stopwatch next to a judge and checking what they're doing. And every judge nowadays, almost every judge will want to say, yes, of course, I know AI and I can use it. They're not going to say that they are technophobes or don't want to try this new technology. At the same time, they also probably don't want to say that they rely on it or rely on it too heavily, because then it looks like they don't do the work themselves, right? So I'm not surprised seeing these numbers. But the reality is, if you talk a bit with the judges, a lot of them are worried about mistakes made by AI, right? We've had these hallucinations that became quite widely reported. They probably worry about bias. They have heard about issues, with confidentiality, that data or information that is uploaded into an AI is no longer private and is shared potentially or accessible to others. And of course, we haven't exactly given them good training on how to do these things. And a lot of courts have no resources. They don't have money or access to professional services like large corporations that use enterprise level AI. And so, we're not giving them really a lot of tools that would enable them to use it in the best possible ways.
Let's dig deeper. Bankruptcy judges, according to US surveys, lead in AI adoption. 32% use it daily or weekly, while district court judges, almost 50%, never used it at all. So why is this gap? What we can learn from bankruptcy courts? Are they so specific in the US?
Let's start with the district courts. Almost every case that comes before a district court judge is going to be different. So there is not really a pattern that recurs a lot. They have to deal with a broad range of cases. In the United States, the judges are relatively well equipped with resources as far as, clerks and assistants go. So they have people preparing work for them. And that is much more suitable if every case is really a separate issue and a different type of case. Now, if you look at bankruptcy courts, they have, first of all, these cases are very, very document heavy. So they'll have to review thousands of pages of documents. And then a lot of their decisions, at least in the early stages, are also pretty much recurring, right? They have to approve plans, they have to stay relief, they have to, claim objections that they deal with. And so there's patterns that are repetitive, and that's where AI really shines, right? Where it can help drafting decisions that the judge then basically just fills in almost like a form. And gets already a decision that is suitable and that is actually accurate, maybe more accurate because AI doesn't forget items, right? As a human, we are much more prone to, I should have listed this and that on the list as well. The AI is going to be systematic and will remind us of that. So I think bankruptcy is a good example where AI can really be an excellent service provider and provide a good assistant level to the judge. And the important thing is that the judge, of course, still evaluates everything and looks it over and uses it in the right way rather than delegating the decision making entirely.
I fully agree. It's interesting question whether the nature of work, instead of calling and taking the whole judiciary altogether, creates a good question about adoption of technology in courts, but also everywhere. So if we should take all the judges and evaluate them together, despite what's their activity. But what worries me most is the asymmetry. In a few days, we'll publish the second global report on the state of AI in legal practice. And the report shows that over 80% of lawyers, law firms, and in-house lawyers are already using AI in their practice. If judges aren't keeping pace, does that skew the balance of power? Because one side becomes disproportionately strong in the courtroom. What's your position?
I mean, it could become a problem. We should still remember the attorneys, they file briefs, they apply for things, right? And the judge makes the decisions. So I'm not so much worried about the imbalance between attorneys using AI and judges using it less. What I'm really worried about is some attorneys having professional AI systems at their fingertips and others not. Because then, the plaintiff may be extremely well resourced. They're using enterprise AI, they have unlimited access, whereas the defendant attorney may be, not having that access. And then, of course, the judge, it becomes more difficult for the judge to decide, how is this just and fair, and to disregard the fact that one party really presents the arguments more eloquently and has more access to evidence, more access to supporting arguments and case law, etc., than the other. So I think the judge, if they are good, they will be able to handle this, even if they don't use AI so much. But between the attorneys, this is a problem, right? And the parties will often not understand that their attorney is not going to tell them, look, I don't use AI, right? Or the other attorney says, I do use it. They may actually get worried because they think that, the work is really done by AI and they just pay a lot of money for hours that are not spent. So I think neither side will really honestly say what they do. And that means we can really have imbalances between the attorneys in the courtroom.
No, it's a really interesting aspect of access to justice. I see your point. And who trains or who should train judges? Because nearly half of the judges report having no AI training at all. Our second global report shows that lawyers today learn more or most about AI informally from webinars, LinkedIn, even X, rather than formal education. So who should systematically educate the judiciary? I'm constitutionalist from my background, so I see if the government steps in, it can create also the risk of violating judicial independence. And in Poland and in Europe, I don't think judiciary is well equipped or equipped well enough to educate all the judges. What's your point of view on this complicated matter?
I think this is really a crucial question, right? We have to ensure that our lawyers are trained and our judges are trained well, and that we respect the independence of the judiciary and make sure that the tools they get support them in their independence rather than channeling them in particular directions of certain commercial providers or whatever. I think we should start thinking about two different groups here, however, and that is the current attorneys and judges, but also the future attorneys and judges. That's where the law schools come in, right? We did a survey recently here in Indiana and asked the attorneys where the training should happen, and pretty much everybody said it should happen at law schools, right? And so I've been teaching this for a number of years, and it's slowly creeping up in popularity amongst the students. But, last time I offered the class, last fall, in the fall semester, I'm going to teach it again this coming fall, I had about 1/10 of the student body in the class, right? So that means 10%, it is an elective course, obviously 10% of our students, they choose AI regulation and 90% choose not to, right? Now, partly this is, conflicts with other classes or scheduling issues, but it still is a pretty scary number, in my opinion, right? And 90% do not prioritize this, are not interested in taking, an in-depth training program on AI while in law school, basically thinking, if I need it later, then I'll take care of it later, right? I've talked to the administration at the law school and I said, well, we should have a component even in the orientation. Give me 2 hours where I'm basically expressing the need and explaining how important this is. And so far, the response has been muted, right? There's obviously always a lot of things that need to be crammed into small amounts of time. But I think this should be dealt with basically from day one in law schools, right? And that's largely not happening. There are plenty of law schools that don't even have classes on this yet. And that's bad, right? So we should change even, that in the United States, as you know, education is heavily determined by what's on the bar exam. If the bar associations would say, well, there could be some questions about AI and the law, wow, then things would change, right? Law schools would suddenly wake up and say, okay, now we have to act. Now, when it comes to the people who are already in practice, attorneys and judges, I think what is really important here, in particular for the judiciary, we have to offer them resources without telling them how to do it. They should pick their own teaching methods and providers and so on, because the government should not say, okay, you have to use this program or that provider. That, I think, is not compatible with the idea we have of judicial independence. So it's more about making it obvious that they need to do something, but then giving them resources rather than directing them and telling them how to and what to do. So I think the bar associations are better at that because they're inherently suspicious of the government giving them instructions. Plus, governments don't want to give them resources because they usually have their own resources, whereas the courts are much more dependent. So they need to be protected in their independence from too much government intervention. I think the trick is to offer them the tools, but give them a smorgasbord to choose from, sort of a marketplace that they will pick what works really best for them, rather being told exactly which providers and which systems they have to use.
The more complicated question, how can we legally and safely weave AI into judicial decision making? What are US constitutional requirements for human oversight? Can you tell us a few words about it?
Yeah, so there's, of course, a pretty active and evolving body of case law on due process, including cases like Matthews v. Eldridge, where it required that human oversight has to be active and remain the determinative part in every judicial decision making. But it also encourages that or allows that AI can be used in the preparation of the work of the judge, right? And I think that's really where the future is, because we have competing interests here. We have the public interest that the docket has to be manageable, right? We cannot tolerate excessive delays. We have to, have resource efficiency, and AI can really help here. Everybody who has tried it on a serious level has seen how, personally, I want to say my work is higher quality and I get more work done with AI. It's not these percentages that we sometimes hear, right? That it's 10 times faster and whatever. That is only if I copy paste the results without checking them, right? But still, I'm getting clear benefits, and the government interest in efficient allocation of resources and keeping the dockets, tight and so on is clearly there. Then, of course, we have on the other side, we have to stop mistakes, right? I mean, if we have hallucinations, if we have, recommendations that the AI provides to a judge that are actually are illegal even, do not reflect correctly the state of the law, and the judge overlooks this, doesn't check it carefully and so on, we may end up with judicial output that is not only low quality, but it is actually violating rights and of the parties and so on a potentially very serious level. And that must not happen. right? And of course, the private interest is also to, not only have, just and efficient decision making, but also to get value for money, right? What people are paying for. We don't want attorneys to bill, 25 hours at $1,200 an hour and get the job done in 25 minutes with an AI without checking the work, right? So in this competition of different factors, I think what we have to maintain is a balance, right? That we allow the use of AI, but we also limit the use of AI. And we require the human oversight factor. And I think the United States has seen some interesting developments, right? The first couple of hallucinations, the judges got kind of a slap on the fingers, right? Sort of, hey, don't do that. And then we had the first financial penalties, and they were in the range like $100 or whatever, right? But more recently, the judges have become annoyed, right? If attorneys are still submitting briefs now with hallucinated case law references, I've seen one case, I think the penalty was nearly $100,000 on the attorney, right? And talk about, hey, do this again and you might get disbarred. So that's the way to do it, right? People will be tempted, right? And I want to give the example of Brazil. I don't know whether you're familiar with the scenario there. In Brazil, they had a backlog. Some people say almost 100 million cases pending in the courts. I think the real numbers are more like 75 to 80 million, but that almost is not a difference anymore, right? And the delays were years and years and years, and people basically, they almost resignated and said, you'll never get a decision because, it's put on the back burner in the courts and they don't think this case is very important, and we've been waiting so long and it may never happen. So the National Council of Justice has really encouraged the use of AI, and Brazil has gone further maybe than any other country, or at least it's absolutely at the top there. And they developed systems to triage cases, to divide them into the ones that are repetitive patterns that could be largely automated versus other cases that are very specific and need more human intervention. Then they cluster them, and then they draft decisions, right? So you have an entire segment of cases, and I don't know exactly the numbers, but I would estimate these are probably, maybe half of all cases that fit into certain pattern. It's another, sales contract, another traffic accident where somebody ran the red light or whatever. You can imagine these kind of cases, right? And the AI is now basically, once they are clustered into these packets, right? The AI is writing the answer, the decision. And then the judge is supposed to of course, look over it and make sure that it's correct, right? And now, let's be honest, right? We're all humans, right? The judge is going to read the first 25 decisions and they're always good and so on because AI is already very professional. And then the judge will start glossing over, right? Will not look as carefully. Hey, it's a lot of work. It may be at times quite monotonous, and the quality of the draft seems very good. Is the judge going to still look sufficiently carefully after months of, waving basically through a lot of these automated decisions? And that is a problem, right? These are issues that we have to foresee because we have this meeting of an increasingly sophisticated technology. Right? Every new iteration of the models is better than the previous ones. Issues that were problematic 6 months ago are already fixed. In 6 months, it'll be better again, right? And on the other hand, we have humans with 24 hours a day, with, kids at home waiting, with, interests and needs and so on that have to be taken care of and concerns. And usually judges are not very well paid, right? I mean, they're not motivated to spend extra hours if the draft from the AI is already looking very good. And the reality is judges will make mistakes or will fail to stop mistakes by not reviewing these cases sufficiently carefully, right? So what are guardrails we could put in place? I think first we have to have a clear role definition. I think the idea that AI is a very good assistant, right? That's what we have to communicate. And that's all it is. It's not going to replace the human decision maker. there are proposals that we should disclose what was done with AI. I think Brazil has done that, right? But of course, what's the remedy? They tell you, okay, your decision has been done automatically. The judge signed off on it. What are the people going to do? I mean, if you have 80 million cases pending, are they now going to challenge this one and wait for 10 years for a human to review it again or whatever, right? So contestability is a nice word if it actually is real, right? It sounds better than what the reality may actually be, right? What I think is important is explainability, right? If you can't understand what happened and how and why, and why one side won and the other side lost, then we have a problem, right? So we have to be able to ask the AI, explain this in persuasive ways, give the legal reasoning that is anchoring it in the statutory or case law or whatever, right? Deals with all the factual points and so on with the evidence and so that it is, you can actually follow why this happened and therefore the decision is persuasive or not, right? And if it's not, there has to be a way of challenging it and reversing it, right? And I think we are learning this, right? We're getting better at it, but it's not going to be perfect anytime soon, right? So how far can AI go without violating due process? I mean, yeah, if we have these kind of guardrails in place, AI can do a lot of magic for us, right? It can prepare, can draft at least parts of decisions. It can summarize documents. But let's go back to the bankruptcy judges for a minute. If you have like 50,000 pages of documents in there, and now you're giving it to the AI, they throw this in a high-speed scanner, the AI summarizes it. Do we know, is the summary correct? Because somebody would have to go back to now manually checking the 50,000 pages. Let's be honest, we're not going to do that, right? And so, yeah, the problems will happen. The question is, what is better? Brazil decided it's better to get these decisions cranked out now, even if a small percentage may not be perfect and may even be wrong, rather than keeping people waiting for 10 years for their decisions, right? And I must say, I can't really disagree with that, right? It's a value choice, but it's certainly not crazy what they're doing there. Right?
I fully agree. I had recently a guest who is a Brazilian officer at the social support system, and she described how they implemented an AI system issuing decisions for maternity support, decreasing the time for issuing such the decision from several weeks or even months to hours.
Yeah.
So nobody questions the decisions because it's much better to get the justice in days rather than wait for it
And
months.
even if we have 1 or 2% that are wrong, right? That's still better, I think, right? Because there is an old proverb: justice delayed is justice denied.
And how do these needs of judges differ from the needs of arbitrators? You are involved in arbitration, U.S. arbitration. So is there any difference? It is kind of providing justice as well.
Yeah, so I was, funny enough, I originally studied in Germany, and so I was trained as a judge, and I was actually offered a courtroom when I had done my second state exam, because they had a shortage at the time of labor judges, right? But of course, that's like 100 years ago, right? So I can't say that I am very experienced with the judiciary, and I'm much more experienced as an arbitrator, both as a partisan counsel, right? Parties prepare and represent themselves in arbitration, and also taking cases as an arbitrator myself. And I must say, I have a lot of confidence in arbitration. What we all have to understand, that the law, I think, Niklas Luhmann and Gunther Teubner have shaped this direction. Law as an autopoietic system, like law fixing itself, right? If law goes off the rails, there will be pushback, and then the next judge's decision will be different, and so on. And in the public courts, this takes time, right? And we can see in the United States right now that there's this polarized political situation, the party in power trying to, appoint politically oriented judges, right, in order to game the system and undermine this autopoietic self-correcting nature. Now, in arbitration, that is different, right? Arbitration is a marketplace. You don't have to use certain arbitration services or certain arbitrators. You are going to look for institutions or for individuals that have really a stellar reputation and have the necessary experience and the knowledge. And if an arbitrator makes a mistake, in particular, if it's not something that is like excusable, innocent kind of mistake, overlooked this and can happen to anybody, that'll ding the reputation of the arbitrator immediately. People talk a lot in these markets. And so arbitrators cannot afford to, issue decisions that are automated, that they haven't reviewed. They get paid very nicely. And therefore, the burden is on them to really provide results that are of excellent quality and fully explainable. What they use in order to get there as their, research tools and so on, that's a different question. But at the end of the day, the oversight has to be there. And that's important because, the public opinion and the marketplace of ideas and the selection process is the only protection we have. There are no appeals, right? If an arbitrator screws up, there isn't sort of the appellate arbitration court where you go to get this fixed. There are very limited options in getting an arbitration award set aside or annulled or so, but usually they don't review the merits, right? They mainly focus on any kind of procedural mistakes. And so this self-policing system, this quality management system in arbitration is very important. And so it's also not surprising for me that the Chartered Institute has their 2025 guidelines on the use of AI in arbitration. The Silicon Valley Arbitration and Mediation Center has issued guidelines already in 2024. If you look, civil procedure rules for courts, how often are they updated? The parliaments are not really interested. This is not stuff that you win elections with. Usually it takes years, decades to update the court rules. And the courts themselves, of course, they have some internal, management rules and so on. And there's maybe some adjustments with case law. But it is very different when you look in arbitration. As soon as any one of the major arbitration centers, let's say the International Chamber of Commerce in Paris, they update their rules of procedure, their arbitration rules, then all the other centers, whether it's Stockholm or Vienna or Singapore or Hong Kong or the ICDR in New York, so they all look, what did they do? Should we also update, right? And this is the kind of system that is very responsive to the needs of the market and is very much self-improving and self-policing actually very quickly, right? Because if one center would be, forging ahead and would, create this reputation, we are the best and, the others are not really up to speed, then they would pick up the business, right? And so the others don't want that, right? So everybody is really trying to be there immediately and respond to these developments and be very professional and very, establish this reputation of taking care of the clients, right, in the best possible way at all times. So I wouldn't worry about arbitration. I think the market takes care of that.
So one last question, looking at the EU's AI Act with its risk categories and compliance requirements, sometimes even described as over-regulation and quite fragmented US approach. So which model you find better suited to governing AI in courts and arbitration?
Tough question. Honestly, I don't really like either of them too much.
Okay.
They both have strengths and weaknesses, right? Mm-hmm. So I think what we are seeing in the United States now is attempts at the federal level to basically prohibit the states from regulating AI, which I think would only be justifiable if there was a very comprehensive, high-quality federal law, like the EU AI Act, right? But the federal government with the current administration has decided we're not going to regulate it, and they also want the states not to regulate it. Now, that's not the usual approach in the United States. What we usually do here is either we let the states experiment, right? We call it the laboratories of democracy, And if there are issues that are affecting what we call interstate commerce, right, where it may need to have a nationwide rule, then either the courts or the federal government steps in, right? But while the federal government doesn't do anything, the states have always taken the lead, and some states more than others, right? And so what, of course, AI is really not a state level issue, right? It's not something that Indiana can regulate effectively and California and New York can regulate differently. It's a global issue. So ideally, we should have, at least some understanding internationally what we can and cannot do here. Problem with international conventions is always you get countries don't really sign on very quickly, and even if they do, they don't always respect them. So I'm not putting my money on that. Would I like to see a good federal law in the United States? The answer is maybe, right? If it was really good, then yes, right? For example, if we let the experts, the arbitrators, the courts, right, the judges, the bar associations, and so on, put together, a committee and so on that drafts the legislation, and then we basically go to Congress and say, we all agree that this is what we should have, and please adopt this, and then they would sign off on it. In this highly partisan environment that we have now, where anything the Republicans want, the Democrats are against, and vice versa, we're not going to get anything good, right? Plus, there's too much money in politics, right? The big tech corporations, they donate the money the politicians need for their re-election campaign, and they dictate what's happening and what's not happening, right? You're not going to get quality legislation out like that. So we have to do it at the grassroots level, right? Bit by bit and so on, which doesn't have to be all bad. Now, the European Union has had that opportunity, right? It created this AI Act. It's a heavy document. It's detailed. It's high quality, right? But of course, 27 member states working in 24 languages, are they going to update this flexibly? Smoothly, with every kind of new challenges being taken care of? You have to be very optimistic to believe that that's actually going to happen, right? And then it ends up also in the courts, right? To take care of nuances that are not written in the AI Act, or where the act is maybe a bit outdated already. And then the court hierarchy system in Europe is problematic, right? Yes, any trial court can submit to the European Court of Justice when they have questions, right? But many of them are reluctant to do so. It takes time and so on. The highest courts have to, but by now we're already years in litigation, right? And the European Court of Justice is overloaded as it is, right? So good effort, but let's see how it evolves, right? Because that's going to be the challenge. The technology is moving so quickly that you cannot have an act that is static and stays behind, right? That's not going to be adequate legislation going forward. What remains to be seen is what these new bodies, that are being created, these institutions, what they can do, right? Whether they can be more responsive and take care of it. Then the European Union might be having the better model if these institutions can really do the job.
I'm quite involved in some works on the guidelines and some codes of practices that implement AI Act, and I see how difficult it is, how many different stakeholders participate in all these conversations, and even implementing the rules is not easy. And speaking about changing them, I think it would be or will be impossible in future. But thank you for this view from the judicial or arbitrators' point of view. Frank, thank you so much for this rich and thought-provoking conversation.
Thank you very much, Michal, for having me. It was a pleasure. And let's do it again sometime, right?
I'm sure we should do it. Our idea is to have this global report on the state of AI in legal practice being repeated and being the main independent source of knowledge about how lawyers approach AI. Maybe we'll extend it also to judiciary. Now we have researched only law firms and in-house departments, but maybe we'll also develop and research how judges and arbitrations work on AI, and we should definitely repeat our discussion. Once again, thank you.
My pleasure. Thank you so much.
And for those listening, if you enjoyed today's episode, make sure to subscribe, check out our past conversations, and share this episode with your colleagues who care about the future of justice and the future of artificial intelligence in legal practice. See you next time on Monday Bagel.